Yesterday, we discussed the issue of compliance with the rules, honorable members, including the modalities for conducting our debates, the way we bring matters that are to be considered by the House, and also the dressing code. I noted even on the media that some of our colleagues here achieved some important milestones, and I was looking forward to mobilizing the House to join them in celebrating. But now our colleague, the prof, is making that difficult for me because with the beanie and the... No. That is against the rules. The rules are saying everyone would comply with the rules, and where there is a need for exemption, the Speaker must be approached to consider the matter and approve. In the absence of that, it is not allowed, Honorable Ampanda. Yeah, to wear that beanie and the jacket. No. We will not debate. That's a ruling, honorable member. And I think at the next meeting of the privileges, we will take this matter up. I just want to say, honorable members, truly, if a member would violate a rule in such an obvious manner, it will be difficult for the presiding officer to enforce any rule in regard to that member. So it will mean, Honorable Ampanda, if you are unwilling to comply with the order of the presiding officer, it will be difficult for the presiding officer to call upon you to do anything, because it means you are actually not recognizing me as a presiding officer. That's the way that I'm taking it. Yeah. So that was an announcement. That was an announcement. Now the second announcement that I would like to make is that in terms of the rules, the sitting of the Assembly is on Tuesday to Thursday from 2:30 to 5:45, yeah, or when the budget is under consideration, also on Monday, 2:30 to 5:45, and on Friday, 9 o'clock to 12:30, if it is so agreed. And that is the practice. But we also have a practice where if we have important matters that we need to consider, and we will not be able to have a sitting during the usual hours, we do meet at different times, as we are doing today, meeting on Thursday in the morning instead of in the afternoon. And what that means is that the normal routine of business would not apply to today. So it means we will proceed to the orders of the day. So that is the announcement. Having said that, yes, on what point are you raising? Yes, please.
I think, Speaker, you are training on you see, there's a day here. There's a day where we had planned with chief whips and we had agreed to mourn one of our late brothers in this house. And on that, and we had shifted on what you are saying now. But that Nakundi, when Nakundi stood up there and said, no, we can't move in that way because of the house rules. And today the house rules are that Thursdays, the house rules we sit for, on Thursdays we sit for questions. And I want to implore you that it's not that we do not want to go into the Met Health Bill, whatever it is that is being debated today, or want to be debated today. No. That every day we come into this house, we are told about rules and orders. Yes, I'll round up, Speaker. I'll round up. Yes, allow me. I'm speaking.
Yeah, you can just let me say what I'm saying and then you explain. You cannot, when I'm talking, you are also talking.
Okay.
Yeah, so I can ask you to round up. You are taking too long.
Okay. Yes,
Yeah.
yes, Speaker. I'm just saying that let us please let us not use the rules. Let us not use the rules when it's preferred and unpreferred.
Okay, fine. I have noted. Please take your seat so that I can respond to that. Yes, I would allow one more so that it's not a discussion, Honorable Cooper. Yes.
Honorable Speaker, I want to understand which rules do we agree on and which rules don't we agree on. Look at the dressing code. There are rules that speaks about the dressing. So is it only that rule that can be passed like that without doing anything, or is it only the others that must be adhered to?
Yes, all the rules as I have indicated. Now I'll make a ruling. Honorable Kambala referred to the point that was made by Honorable Nekundi. And the point that was made by Honorable Nekundi is exactly the one I'm making today. So on that day, when we started, I started with the routine of the day. And then Honorable Nekundi said, but today we are not sitting during the normal hours of the sitting of the assembly. And therefore, the business routine, the routine of business, does not apply. And I agreed with him. And we stopped and we proceeded directly to the matter that brought us, which was the budget. So you are actually pointing to a precedence that was agreed upon without any dispute. Now, having said that, I would like to emphasize again, honorable members, that Honorable Dr. Ampanda, you must rectify your dressing code. Honorable, you cannot have a beanie, you cannot have that jacket, and at the next meeting, all of you, the clothing must align with the dressing code. I have indicated, honorable members, and I will repeat it once more. The rules do not say the ruling of the presiding officer cannot be challenged. The ruling of the presiding officer can be challenged, but there is a procedure established by which that ruling is to be challenged. And that is to say, the matter is brought before the assembly on the recommendation of the standing rules, and the assembly can overturn it. So if the presiding officer is misinterpreting the rules, this House has an opportunity to overturn that ruling. But then the rules proceed to say, until that has happened, the ruling of the presiding officer must be complied with. Yes, and so the matter is Honorable Ampanda, Honorable Kambala, and the Honorable Karola. Yeah, yeah, yeah. Honorable members. Yes. 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 Honorable member, please don't speak from your sitting position. Honorable members, every time a member gets up, please state the rule under which you are rising.
So, Speaker, firstly, the rules, the dressing code is not whether you like how the person is dressing. The rules are very specific. So it indicates exactly for a male, for a female. It's not just because I don't like your jacket. You must indicate that it says long sleeve.
What point are you raising, honorable member?
No, I'm raising a point of procedure. So, Speaker, I'm simply saying that when we are making rulings, we must go and indicate clearly that in terms of the rule, which is the rule that has been violated. Certainly, it's not going to be the case that I don't like the shirt that you are wearing, therefore it's out of the rules. No, it must be, I will not have any problem on enforcement of a ruling that is in terms of the rule. But when somebody just say, like you, I don't like the way you are wearing. There are people here who don't wear belts. In our culture, it's only when you have a woman pregnant that you can't wear a belt. But they stand up with the courage to complain about how they feel another person is wearing. So the rule says for a female, like this, for a male, like this. It doesn't say the texture. Yeah, so when the only thing that perhaps, in conclusion, Speaker, the rules doesn't speak about what type of jerseys that you must wear. It says long sleeve, short sleeve, and it describes it. But the only the issue that I want us to engage, Speaker, is that if is the case in the case of winter. I woke up this morning very, very, very cold. So I want to actually understand, are we saying, because I did not find it, you remember when we had this issue, you said a cap, yeah? And there's a definition of a cap. But this gear, when in winter, have you ever seen me, Speaker, in summer wearing this? So all I'm saying is just that, yes, all I'm saying, Speaker, is that let's enforce the rules, not whether we like what a person is wearing or not. So can we take up the issue of the hoodie? Yes, can we take it up separately?
To express concerns and disagreements with the ruling of the presiding officer. But the rules prescribes a procedure. And the way you are doing it now is not in line with the procedure. So I will say, yes, that matter can be taken up. But in terms of the rules, once the ruling is made, you comply with it, and then you take up the matter. That platform is provided for under the rules. I think we have dealt with this matter, honorable members. Yeah, no, I would now really, honorable members, I want to proceed to the business of the day. Yeah. Because in terms of the rules, the presiding officer can also decide that we proceed if these other issues are taking up too much time. Because I can't have 6 people speaking on the same thing. And this is the list that I have here. So can I please have your understanding that we proceed, honorable members? Yeah, so now I will ask the secretary to read the first order of the day, and I ask Honorable Ampanda to remove his beanie and you know, I don't know what that one is called. And I would also like to have it recorded that the dressing of Honorable Ampanda, Honorable Kambara, and Honorable Karola is not in line. And from the next day, because I can't ask you to. Yeah, honorable members, can you please take a seat? You don't have to do it that way. Yeah, yeah. Honorable members, challenge that at the committee. Yeah, honorable members, the secretary will read the order of the day. The secretary, proceed.
Resumption of committee stage, mental health bill.
Honorable members, please take your seat. Okay. Does the Honorable Minister of Health and Social Services move that the Assembly now goes into committee? Any objections? Who seconds? Agree to. I now call on the chairperson of the whole House Committee to take the chair.
Yes.
Okay. Yeah.
The whole House Committee is called to order. The whole House Committee. The whole House Committee has to consider the mental health bill. When progress was reported yesterday, 29 April 2026, Clause 20 is to be amended. Clause 21 to 28 were put and agreed to. Clause 29 is to be amended. Clause 30 to 63 were put and agreed to. Clause 64 as amended by the Minister was put and agreed to. Clause 65 was put and agreed to. Clause 66 is to be amended. I now put Clause 67. Any discussion? Any objection? Agreed to. I now put Clause 68. Any discussion? Any objection? Agreed to. I now put Clause 69. Any discussion? Any objection? Agreed to. I now put Clause 70. Any discussion? Any objection? Agreed to. I now put Clause 71. Any discussion? Any objection? Agreed to. I now put Clause. What is the issue? Clause. Honorable Ampanda, clause. We are done. I looked around.
Secretary is telling you there.
I now put Clause 72. Any discussion? Any objection? Yes. There is an objection. Can we divide the House then? You must stand up then, the one who objects. Objected. One objection. Agreed to. And I put Clause 73. Any discussion? Any objection? Agreed to. I now put Clause 74. Any discussion? Any objection? Agreed to. I now put Clause 75. Any discussion? Any objection? Agreed to. I now put Clause 76. Any discussion? Any objection? Agreed to. Objection. Objection. We record the objection. We record the objection.
Deputy Chairperson.
We're at Clause 76. Prof.
Yes. I just want to get clarity that the executive director, a judge, a magistrate, or any person delegated by the minister may visit a person detained or admitted in terms of this act, and such visit may be made without prior notice. So, Minister, what are we to make? For example, then it says the executive director, a judge, or a magistrate, or any person delegated by the minister. Does a minister delegate a judge? I've never seen it in any law that says that the minister may delegate a judge. So maybe you can clarify that aspect. But it also says, and such visit may be made without prior notice. So if a judge can visit without a prior notice, but at the same time it says that the executive director, a judge or a magistrate, or any person delegated by the minister? Or are we reading it to mean that the executive director, a judge or a magistrate are not linked to any other person delegated by. So I'm just having really difficulty in trying to comprehend, because otherwise it would be an absurdity. So, but even if I try to reconcile myself with that, it also says, and such visit may be made without prior notice. So is it now the judge who can make that visit for people detained without prior notice? Or is it any other person who's delegated by the minister? Must you be delegated by the minister first and you make a visit without a notice? Or what exactly is it that is being said? I just wanted to understand that.
Honorable Minister Lugunda.
Chairperson, Honorable Member, the statement is quite clear, but let me read it again so that we can all be on the same page about what it means grammatically. Number 76 says the executive director, comma, a judge, comma, a magistrate, or any other person delegated by the minister. So no, a judge or a magistrate is not delegated by a minister, or any other person is a separate subject that then refers to the fact that any other person that needs to make a visit for whatever reason can be delegated by the minister to visit a detained person or an admitted person. If the honourable member has a specific, considering that we're at committee stage, if the honourable member has a specific way he would like it amended at this particular stage, he can propose that. Thank you.
Honorable Mpanda.
So, yeah, I did consider that response that you are giving. That's why I qualified it. Perhaps that's what it means. So we are together there that the executive director, a judge or a magistrate is a separate category. Any other person delegated by the minister may visit a person detained or admitted in terms of this act. Now, but remember, the previous section of the act says that you can even individually check yourself in at the age of, is it 14 even, it made it worse. You can check yourself, but what does not make sense here, I understand, for example, if a minister delegates somebody or any other person wants a certain process to delegate somebody to do that. But when does visitation, that's why I just don't understand, visitation by patients. Because if it's my child that is there, do I need a delegation by the minister for that to have happened? So it's the only people who are the judges, the executive director, a judge, and the magistrate are kept separately. So that's why they are identified. Then there's a second category of any person delegated by the minister. So visitation of patients, because obviously there are other laws that also affect right to life and things like that. But I'm saying, if my child is there, since I'm not as a member of the public, do I need to be delegated by a minister to visit a person who's admitted there? Because the problem with this thing is just that as a member of the public, once you have that, meaning visitation of patients who are admitted in terms of mental health becomes a regulated area. Now when it becomes a regulated area, there is a specification on what's supposed to have happened. But then there's an absurdity that such visit may be made without prior notice. So that's the first aspect that I need clarification on. So we have dealt with the first one. So where does a member of public come in? Because it doesn't clearly indicate how. And then what does the last one mean, that you can do it without prior notice? Because that's what it will mean. Because if my child is admitted, and the hospital will probably have known the record, because there are two things. You can check yourself into the facility in terms of the previous section, or you can take your child so and so. So the last part, without prior notice, that's what when my child is admitted already, I can go. The hospital will have, or a facility will have visiting hours. But the problematic thing is now any other person delegated by the minister. Yeah. So I've never seen visitation that are regulated by act. Visitation to hospitals and facilities is a normal procedural thing that are not necessarily, unless maybe there's something specific that the act is trying to see that. If, not to take up much of the time, if we cannot, if it doesn't appear clear, you could always see how we can cure it, because it's a problem. Once you regulate something, the purpose of a law is to include and exclude. Yeah. So once you have it, it's very specific, and it's a bet that all of us will have to lay in it. Because, for instance, you would see in Ward 16, for instance, at the Shakati hospital, you will see that it's not a normal ward like where you go and visit because there's danger that is involved and things like that. That's why you will see that Section 77 has provision for regulations. You see, I would have understood if the minister, in terms of Section 77, goes and develop regulation in relation to visitation. But in the current framework of 76 is a bit problematic for me.
Honorable Minister.
Chairperson, honourable member for the question. So the honourable member is 100% right, and we do not regulate normal visitation. That is 100% clear. What we do in the actual regulations or in the rules, pardon me, of facilities is where we stipulate visiting hours and all. The honourable member, though, must be clear on the fact of how mental health facilities function. Now, mental health facilities, because of the nature of it, you must remember this bill deals with forensic as well as non-forensic patients. And this is a well-known rule around. You cannot just go into another country, for example, as a minister from another country and say, I want to visit a mental health facility. Due to the nature of the cases and the security involved, because we also house forensic patients, this is then what we are dealing with in this law, and it is rightfully so, because other members, senior members, even from other countries, may not merely say that we are visiting, we're popping up at the mental health facility to see how things operate. That is not how it works, and that is the part that is being regulated by this particular part of the Act. And it is justified that it does so due to the nature of patients. Thank you very much.
Honorable Ambanda, it's clear.
For instance, that is understood very well. That I don't have an issue with anybody who's so designated by the minister. But what I'm saying is that you will see, for example, in terms of clause 21, that will eventually become section 21. And if you go there, it speaks about, remember I spoke about the child, then it continued to 6. If a patient is a child, the health facility in collaboration with officials from the ministry responsible must make every reasonable effort to facilitate the child's ongoing relationship with his or her parents and other family members or legal guardian. So I'm not talking about certain things that are out there. I'm talking about things that are even in the very bill in terms of clause 21. So we are talking about parents, we are also talking about other family members. There is only one clause. There's only one clause that deals with visitation. That's why I'm saying I find it rather strange. It's not that I'm not alive to. There must be something that the health practitioners or whoever it is that have been working on, there must be something that they are trying to get to. Definitely. But are they getting to that? No. Proceeding from 21 minister. Yeah. So the aspect of somebody who's delegated by the minister, the aspect of ED, the aspect of magistrate, if there are any other dispute legally, that one is understood. But clause 76 actually goes to regulate visitation. That's what I'm sitting with a problem. If it was in the rules, if it was in the regulation, I would be able to understand. Because if somebody wants to, how do we deal with visitation? That's what it is. But again, if I interpret it, if we leave it like that and I interpret it on my own way, I can show up, such visit may be made without prior notice. But can I show up just randomly if Honorable Amtenya is in a mental facility? Can I just rock up randomly without a notice in terms of 76? Yeah? Because remember, the regulation that you are going to develop and the rules must not be in contradiction with the provisions of the Act. So if we lock it in 76, we are good to go with that. You cannot go and develop other regulation separately. The regulation must only further the objectives of a provision such as 76. So that's why I'm saying is that if we cannot perhaps be able to be clear and find out exactly what is it that we meant there. Because the first one, we are clear. You indicated there we are together. The second aspect, person who's delegated by the minister, we have clarified that those categories are separate. But the problem is that then if the sentences only is indicated that the executive director, a magistrate, or any person delegated by the minister may visit a person detained or admitted in terms of this act. Let's assume it ended there. Yeah? But then he say such visit may be made.
Honorable Kambala. Not even Honorable Ampanda is saying anything.
We are engaging with the minister. That's how I understand this process is. Because that's why I indicated the deputy chairperson. Minister, don't be disturbed by those ones. Yes.
You continue, Honorable Ampanda.
Yes. So what I'm saying is that
you are also distracted.
We had clarified the first issue. And the minister had responded, and she was talking about people who come from other countries. We have dealt with that. There is no issue. But the thing is that that's why I refer to 21, is that we have a clause on visitation of patients. Once we have a clause on visitation of patients, it basically indicates what it is. But where does members of public fall? Because you are talking about that ongoing relationship that the ministry and the administrators of the act would have, that responsibility that they will have. So if we are unable to understand, to find each other, I'm sure in this process of amendment, not to say I propose to write it like that, because I'm saying, let's go back to those people. Maybe there is something that they are trying to communicate, which they are not communicating. Otherwise, you could have that 76 out, and minister can still develop regulation in terms of the next clause, which is 77.
Honorable Ampanda, Amtenya.
Deputy Chairperson, I also want to implore that we stick to the 5 minutes time. Then one can come after the 5 minutes. Please, Chairperson. The other one, it's on this visitation, my understanding, yes.
Honorable Amtenya, it's 3 minutes in fact.
I mean 3 minutes, yeah. The visitation of patients, I would want to propose, possibly because what I'm seeing here is addressing the official visitations. And would it harm if we are to put the word official before visitation there, so that it reads official visitation of patients? Because I think this is to regulate, for instance, if a member of a certain ministry is in the ward and is admitted, and therefore the ED or the ministry wants to affirm to that, then they have that official visitation, because they are not family members. And for me, as a brother to a patient or a parent to the patient, in what capacity is this individual, an ED coming or a judge coming to visit my son or to visit my brother? And if it's an official visitation, then obviously it's because of the responsibility of that ministry. Therefore, I propose if we can add the word official, and then it reads as official visitation of patients. That is the only thing that we can regulate. All other regulation, visitations, I don't think we need to regulate that. Thank you.
Thank you very much, Honorable Amtenya. Dr. Lugunda.
Thank you, Honorable Deputy Chairperson. Thank you to both honorable members. And yes, we approve the proposed amendment to perhaps use the word official. As the honorable members rightfully said, we cannot perhaps legislate normal visitation. So yes, this is with regards to official visitation. So that amendment will be made. Thank you.
Honorable Ampanda.
So if we indicate that, that would have addressed my issue, because then we itemize it. Thank you very much, Mewiliko. So we itemize it and isolate it specifically to official. So then we would not have had some sort of, because once you have a provision, you have it. You cannot go around it. So thank you very much, Minister, for that. At least it addresses my issue that I had specifically with that.
Thank you very much, Honorable Ampanda. Any further discussion? Any objection? Hey, wait, we go close by close. Any objection? Agreed to. Close. I now put clause 77. Any discussion? Honorable Ampanda.
I want to just understand, because Minister, I just want to clarify that if I was very clear on a matter, I would have proposed a clear amendment. So at this stage, I'm just seeking understanding. You see, for example, and it flows from the point that I was making earlier, that regulation, the power to make regulation is to further the objectives of the Act itself. So you see, for example, in clause 77, 1H, the minister may make regulation relating to establishment and implementation of educational programs for patients admitted at health facilities. That is a very strange and wild power that, because first of all, educational programs are not regulated, are not developed by regulation. So in other words, it basically means, in the reading of this act, it basically means that the minister can therefore make regulation that says, I'm establishing an educational program. A minister responsible for health would be establishing educational programs for patients who are admitted. So I've never heard it and seen it anywhere where a minister has. This is a very serious provision. You would have had it in the body of the Act itself. So a person is admitted, now the minister can develop educational programs. So now these educational programs, perhaps in the definition is there. Which educational program are these going to be developed for people who are admitted in these facilities? I just want to, before I even develop it further, I just want to understand exactly what is the wisdom of 77 1H, H Roman 1.
Honorable Minister.
Nobody else. Okay. Thank you, Honorable Deputy Chair. Honorable Member, the wisdom in it is that sometimes patients are admitted for weeks, months at a time, sometimes even years, and end up missing on fundamental educational programs, which unfortunately does fall under myself because we are responsible for holistic care of patients. As you are aware, in the mental health facilities, patients a lot of the times don't get admitted today and discharged tomorrow. So yes, education is a very key part. Perhaps there what we can do is include a clause to say in conjunction with the ministry responsible for education. However, the clause definitely must remain. Thank you very much.
Honorable Ampanda, any clarity?
So the minister has actually clarified now, and in that clarification it creates a bigger problem. So the clause doesn't say, for example, yes, this person is, for instance, a person is admitted in the correctional facility and you are a student at NAST. Yes, the correctional facilities and the minister responsible for Home Affairs may make regulation in terms of the Correctional Act on how the prisoners are going to be writing exam. Granted, you are correct to say that a person may be admitted in a facility for a longer time. Therefore, a regulation is needed to deal with that. But that's not what this clause says. This clause does not say to develop regulation with regards to educational program. It says establish and implement. Meaning you are going to develop educational programs. You are going to develop regulation to establish, another way to bring, to give birth to it, and after giving birth to it, you must implement it. If the wisdom was the way how you are explaining it, it makes absolute sense, because those people are now under your care. They will come in there, the parents will say that, no, my child was a final year student at this so-and-so university. So if the wisdom, as you are indicating, is to actually say people come here and they have obligation in terms of educational facilities that they are doing. Well and good, well and understood. But the provision here is that the minister may make regulation relating to the establishment. Yeah? So in other words, those programs, those educational programs must be established by the minister and must be implemented. So you must develop curriculum for those programs because they are educational programs. And once you develop the program, you must have this program accredited. But I guess it could be, we could change it perhaps in terms of what you are saying it, to achieve the
Honourable Mpanda,
objective.
Conclude.
Yes, to achieve the objective of what you are saying, perhaps to say the minister may make regulation relating to the implementation. Then we perhaps remove the establishment, because you are saying that they come in or they want to enroll, and therefore you probably want to have regulation related to how that is going to be done. But the word establishment and implementation means absolutely something else.
Thank you, Honourable Minister.
Thank you, Honourable Deputy Chairperson. It is well agreed. We will remove the word established. Thank you very much.
Thank you, Honourable Minister. Any discussion? Honourable Mpanda, it will be difficult. It's fine. Any discussion, any objection, agreed to. I now put clause 78. Any discussion, any objection, agreed to. I now put clause 79. Any discussion, any objection, agreed to. I now put clause 80. Any discussion? Yes. Honourable Mpanda.
So the transitional minister in other jurisdictions, in South Africa in particular, where this act has been modeled, there was problems with transitional mechanism. So I just wanted to get assurance from the minister that, you see, it says savings and transitional provision. It says any regulation, application, report, inquiry, finding, request, return, direction, examination, or appointment made, held, or given, any medical certificate or other certificate order in terms of this act, summons, in that one, in terms of this act, summons, warrants issued or made to be given, B, will come back to it, condition imposed, in terms of any provision of any law repealed by this act which was in force immediately prior to the commencement of this act, is deemed to have been made, held, issued, given, imposed, established, and done in terms of a corresponding provision of this act. Okay? Any forensic mental, then it continues.
Honourable, propose what you want. Not discussing, but propose what you want to be reflected.
You ask any discussion. We will come to any amendment.
The whole House Committee. Continue, Honourable.
Okay. So I just, firstly there was
we
that.
We must not be irritated by others later if they do the same thing.
Okay. So there was, so I just wanted to check whether there was a coverage, because only in terms of that specific act.
You will be moved out of the House if you don't stop. It's an irritation. You don't even have the respect for your president.
No. Just yes. Address him, not through me.
Continue.
Yeah. So he's a member in his right. So
even though.
Yeah. So because the minister, why I'm asking about transitional mechanism is that because this mental health bill, what it does in terms of application, it actually not only in terms of that act, because for example that clause 20, it speaks about you now have a situation where even you as a medical practitioner, you have made diagnosis, I'm sure, in your practice with regard to mental health status. So this act is applicable to any other professions, not just psychologists and psychiatrists. So to what extent can you assure us that the transitional mechanism have covered all those areas, or we need to put a provision that says, or any other profession or whatever it is that are impacted there? Because you see in B, in conclusion, as I conclude, it says medical certificate and other certificate, you can just contribute if you want.
Honourable Mpanda, you don't address another member. She raised on a point.
She's just there saying, she's not contributing.
Honourable, yeah. Ampanda.
Chairperson of the whole House Committee, Assistant. The procedure I rose on, I'm saying now it's an open discussion, but the time, are we now just discussing openly without time allocation, or how are we proceeding? Because if there's no time allocated to a specific speaker, it will be very, very difficult.
It's 3 minutes.
Thank you very
Thank
much,
you.
Honorable. Can you conclude, Honorable Ampanda?
Yeah, thank you. Thank you. So I think, Minister, you got that first aspect, eh?
It's your people in the group
Minister?
who does that. I don't know what is.
No, it's you who did
Honorable Ampanda, can you continue?
Okay,
Don't be distracted.
thank you.
Continue and conclude.
Medical certificate, other certificate. I'm talking about 81B. Order in terms of this act.
Are you at 80 or 81?
No, 81B.
Okay.
Yes. Medical certificate or other certificate, order in terms of this act. So I'm just having a difficulty. The first aspect I've already dealt with. I'm having a difficulty in that framing in terms of this act. That means it's the retrospective aspect that the other provision I understand. But what is the meaning of that in terms of this act? The medical certificate, because obviously when this act is brought into operation, the medical certificate and other certificate would have been issued in terms of the act, in terms of the application, in terms of whatever it is that is done there. So what does that mean in terms of this act? That only those two aspects.
Thank you, Honorable Ampanda. Honorable Minister.
Honourable Member for the question. So, with regards to this particular clause, what we are trying to do is avoid leaving a vacuum in the law. And that is avoid leaving a vacuum in the law. And ultimately that is the goal. This is standard, especially where or in cases where we are repealing a law and introducing a new law. That is ultimately the purpose of this. And we do have to say things done under the law to be repealed, otherwise they will cease to exist. So it is in order to basically state that there are other laws, there are other, as listed in clause 80, that can coexist together with this law. It avoids leaving a vacuum, and it avoids the insurance of the fact that then these laws may cease to exist because we have not pronounced ourselves. And so clause 81E covers any other act that might not have been listed, and it definitely should be in terms of the repealed act. So that little clause there can be amended. Thank you very much.
Thank you very much. The Honorable Ampanda.
So, okay, so you are assuring us that it addresses what my earlier first point that I made, so it's addressed there. But Minister, your second aspect then problematizes it, and if we are following. How I understood transitional mechanism is like this. It means any other provision that has been, any other certificate that has been given before would have been interpreted as being given in terms of this law. That's how it is. So any other thing that has been done in the past, but look at the language there, or unless I don't understand it. The language says 81B, medical certificate, other certificate or order in terms of this act would have been construed to mean it has been awarded in terms of this act. You see, 81 have A, B, C, D, 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 and then continues with a qualification that is going to have been deemed to have been made, held, issued, given, imposed, established, or done in terms of the corresponding provision of this act. So it's supposed to be any other law, it's supposed to be deemed to have been done in terms of this act. Now the problem is 81B says this act, and then again goes and say this act, because you are simply saying anything that was done by this parliament must be seen and accepted to have been done by this parliament. It's an absurdity. It ought to have said that anything, any medical certificate, any summon or and all those things done in terms of previous provisions of any other act should be deemed to have been done in terms of this act. Now what you have in B, it says have that. That's why I'm saying maybe I don't understand it properly. But it says there, medical certificate, any medical certificate or other certificate order in terms of this act. But then it's either, then it goes there and say, you must look at it as having been done in terms of this act. This act being done in terms of this act. But E is correct. E is correct that.
Honorable Minister. Honorable Amtenya.
Deputy Chairperson, my understanding on this one is this act, the one that we are looking at now, also considers and acknowledges a medical certificate. It considers and acknowledges all these other certificates. I think that's what it's referring to. To say that medical certificates that are considered by this act, defined by this act, or someone's warrant or authority issued, made or given, it still should be. And I think that is where Honorable Ampada is talking about, is to say this act as well considers that there must be medical certificates.
Why?
Yes, this act as well recognizes medical certificates.
Are you answering Honorable Ampanda?
Yes, Chairperson. No, he's the one that is a concern. And that's what I'm trying to clarify.
It's the minister that must clarify.
Yes. So
it's the minister that must do that part, Honorable Amtenya.
No, it's not. No, it's not the minister. No, Chairperson.
No,
Chairperson.
No.
Chairperson.
Kampala.
Chairperson.
You have been misbehaving since we have started. Yes. Since we have started, Honorable. No.
Chairperson.
That's unacceptable. You are unacceptable. All of us that are misbehaving, must end that. No.
Chairperson.
Is it you who must tell him?
No.
Is it you who must tell him? No.
Chairperson, I fail to understand when we are saying this bill can only be, or contribution can only be given by the minister. I don't understand it. I thought we are debating and discussing these issues.
Now.
Not debating, but discussing these issues.
No, we can also, okay, discuss.
Yes, so then
your proposal, Honorable, your proposal.
I'm simply saying, I was still clarifying the matter that is still as is.
Honorable Minister.
Are we saying that it's only the minister that responds?
Very much, Honorable Deputy Chairperson. Just very briefly, what the Honorable Member has said regarding the medical certificates and all ultimately should read regarding the repealed act. Regarding the repealed act, so not this act. So it is regarding the repealed act. So that amendment will be made. Thank you very much.
And to the concern of Honorable Amtenya? Okay. Any further discussion? Honorable Ampanda.
Deputy Chair, I just want to say my concern has been addressed because the minister indicated she's referring to the act that is going to be repealed. So in other words, there's no longer a positive correlation. So thank you very much, Minister. So my issue has been addressed as far as that is concerned.
Any objection or any objection? No, we don't debate now. Agreed to. I now put clause 81. Any discussion? Any objection? Eh? Agreed to. Honorable Brankman.
What do we do going forward if we have, like yesterday my colleague spoke about the areas where the bill is silent on, like the traditional healers and our religious leaders traditional healers. People are
There's a
going to
difference
them,
between
whether
traditional
we like it or
healer and a
not.
witch doctor.
You are going this tomorrow, you'll be crossing to Zambia. I always
And
see.
us pastors were praying for people for deliverance.
Christina.
The bill is silent about the rights of the healthcare workers. How do we go on? Can we add it as a new clause, or going forward, how is it supposed to happen?
We want to add.
Can the minister maybe clarify
quiet
what
on
is supposed
suicide.
to happen? Yeah, it's quiet on suicide as well. So there are things that we wanted to add.
Before Minister replied to that, Honorable Engari.
Yes, section, we've been saying clauses and sub-clauses the entire time when we were debating this bill. And so my understanding is that the document before us is not an act yet, but if you check that clause 81, sub-clause 1, it actually says that this act is called the Mental Health Act. Is there perhaps confusion? When does a bill become an act? I think that there needs to be that clarity, because should it say that this act, if at the beginning, at the very beginning, it says this bill? Thank you.
Thank you, Honorable Minister of Health.
Allow me to work backwards. I think Honorable Hengari's question, perhaps that I can address a bit faster. That is correct. It is still in bill form, and definitely it should reflect that and not an act. We definitely take account for that, and we definitely understand the legislative process of when it becomes an act. So that then will be amended to be reflected accordingly, as it still must pass through the National Council. Well understood. Thank you. Regarding the question on the clauses, Honorable Deputy Chair of the Whole House Committee, this question was raised yesterday, and from my understanding of this particular lawmaking process, there were sort of stages whereby this was supposed to be raised if an omission was felt was quite severe and would have diverse or adverse consequences that should have been raised at various stages. Unfortunately, at this particular stage, we deal clause by clause, and if we got to a clause where the honourable member would have wanted to insert that particular clause, the honourable member was then free to raise her hand and to then ask for that clause to be included. But we cannot backtrack now to include a clause. What I definitely can once again state is what the honourable member stated yesterday about perhaps the aspects that have been missed. There is a bill that is currently in draft form and in the works, and anything else would then be included in other forms of law, but not this one as the stage has passed. Thank you.
That is the response yesterday. Honorable Lutuhesi.
Thank you. I want to understand, how can we include a new clause that was omitted on a clause that does not exist? This is why it will not come. Because when we are talking about the one that we want, like for me, the one that I wanted to include is the new section, which should be integration of traditional healers and the religious healers. It does not exist anyway. There's no way from your number one clause up to the last one where I can insert it. It's a new one. How do I insert this new important aspect that you do not include in your bill? On which clause? And it's very important that we cannot leave it. We cannot ignore things that happen.
Thank you, Honorable Lutuhesi. Honorable April.
Deputy Chair, thank you. Actually, mine is a concern, so maybe we can probably finish the questions de facto to the bill, and then I'll come in, because there is serious undermining of other people's knowledge in this house. And one thing that I have in particular studied and learned at the university is that you may be a professor in one thing, but in the other thing you are an idiot. That's why we are here. That's why we are here as a collective. It's a university language.
Was it referred specifically to somebody?
So we are here to work together. We are here to work together, to complement each other, to reach and achieve a common goal as one parliament. I want to caution us. We are stifling debate. If some people who start to contribute from a vantage point that I regard as being supercilious, that's not how we should do job in this house. Let's understand that we are from different backgrounds and we need to work together to achieve the common goal, and that is to pass good laws for good results outside.
Exactly.
So therefore, I want to appeal, let's not be diminutive of other people's contributions. Let's try to understand, and especially the interjections, those small things that people are pelting into a serious discussion to distract others, to be focused. This is not parliamentary. It does not help us. Let's respect each other and build our job in this house, departing from a premise called respect for each other. Thank you so much.
Those are the basic things that were spoken to. Honorable Kampala.
The whole House Committee, I think I'll go back again. I'll try to assist my colleagues over there. You see, Chairperson, Deputy Chairperson, when we started with this bill, we started this bill debate on a good note. I'll start from the Chief Whip's meeting to where we are now. And Honorable Viveko Nekundi was the one that, with the senior leaders here, Ina Ngari and Winnie.
Close, where are you? Which close are you?
No, just wait. You allowed me also, just to learn. Honorable Viveko Nekundi said that no, in the third reading, and the table office can on record, yes, on record, that no, in the third reading, if we had missed anything in the bill, if we had missed anything in the bill from page 1 until page 100, we are able to rectify it in the third reading. That was the assurance we were given. Now, it makes it now, the minister's response diminishes that fact. So the minister, in actual fact, when she comes for her third reading, she must ensure that those silent matters that were raised in this house are included. You see now, you see? Just now, Honorable April said, let's not diminish each other. Now she's just laughing.
Thank you very much.
So my concern, it's either my concern, it's either our concern on this house is not, it's immaterial. Because you are asked, oh, see, she's saying again it is. We are asking,
what is happening?
the bill is silent on traditional.
We have heard
yes.
that part, Honorable.
Now, can the minister assure us that in the third reading, in her third reading, our concerns are addressed?
Thank you very much.
It's simply put.
Honorable Shifeta.
Honorable Deputy Chair, I just want to assist. You see, traditional leaders, traditional healers are not regulated by our law. There is no really fully enforceable law that regulates traditional healers. I think there's a bill that is in the process called, can I have the floor? Can I have the floor? There's no problem with traditional healers. But the problem part is that you cannot include it in this bill now. Because the bill of traditional healers is still coming. What we call, I think, traditional was I think that proposal of traditional health practitioners bill, they are not registered anywhere. So to include this will again kind of cause some problematic provision in the bill. So what can be done? There's nothing that will be thrown away. There's nothing will be thrown away. Wait until the traditional health practitioners bill comes. Then in the process can be included because
Thank you. Thank you very much, Honorable. Honorable Udese.
Deputy Chairperson of the whole House. What I'm trying to say is that this whole bill is silent on that. It does not authorize, nor does it prohibit. You understand? So if we are going to deal with mental health, we are talking about taking patients to designated health facilities where they are supposed to be helped. But then we have a situation where 70 to 80% of our own people, even all tribes, I shouldn't talk about Zambezi people alone. You consult religious leaders, you go to churches, you get prayed. But here, there's nothing that says we prohibit you to go there, go to the hospital first. We want something. Even prohibit if you don't authorize, please.
Honorable Nashinge.
It must be allowed.
Yeah, thank you, Honorable Deputy Chairperson of the whole House Committee. I would
Honorable Moshindanke and Brankman. Honorable Nashinge is on the
Yeah,
floor.
thank you. Yeah, I really just wanted to emphasize one thing. It's unfortunate the Honorable Minister is there on the phone giggling and all that. A clear sign that we are not taking what we are doing very seriously, and it's offending, to be honest, for an honorable minister who has sworn to come here and protect the interests of the Namibian people. So let us take each other serious. Now, this bill, we are actually here to perfect what is not perfect for us. A citizen of this country on behalf of the citizen of the people, of the citizens that have sent us here. So now we are saying, we are talking about mental health, right? A serious problem that also needs serious intervention from different angles. For example, I asked the issue of, for example, the understanding that we have as people of this country, as blacks, is that mental health is when somebody is running naked. That is the reality. That is the understanding that we have. So from here, we need to push and come in with campaigns to make people understand that mental health comes in different shapes. Now, the issue of traditional healers and religious leaders, for example, some of you have traveled to Uganda to see Prophet Kende. Simply because these people have a role in the society. Now, this bill smells South Africa in and out because they were organic enough to customize that law to their issues as people of South Africa. So, what we could have done is also to look at these issues that are being raised here so that we perfect this law moving forward. So we can't now say, because it's our law, right? Now we are coming here changing while we had made a commitment yesterday that we are going to look into these things. Now the Honorable Minister is saying it's impossible. So we are saying you cannot ignore traditional healers and religious leaders in the society. And they are there. Our people are going to these people. They play a role in the society. So this law should also include them so that they play a role and they meet the Minister of Health and the government halfway to address the issues that we are facing. We have, 7,000 suicide cases in this country, in the continent, in the world. We have a serious problem. So we shouldn't be here on the phones and just fighting, competing. We are not competing here. This is our law. That's why we are saying we are supporting it 100% because we have a serious problem.
Thank you very much, Honorable. Now I want to understand and I need guidance. We have agreed to clause 81, which will take us to the schedule. I do not know on what we are speaking. Because I gave her a chance to say something even though it was wrong. It was wrong when she wanted to come in for clarity. She came in for clarity, but it has opened up a whole Pandora box of discussions. Yes, yes. Honorable Minister.
Thank you. Thank you very much, Honorable Deputy Chair. Let me first address camera. I'd like to address the issue of the cell phones because
the minister is on the floor.
It gets clipped and then it goes. Yeah. Should I sit and wait for him? Okay. Good. So on the issue of cell phones, it is well noted that I have to consult. The legal drafter is
Honorable
on the
Minister,
phone.
don't
and
explain yourself on the cell phone and come to the point,
legal
please.
drafter is on the phone, and I must consult so that I do not do a disservice to the same people that you are talking about. My qualifications are an MBCHP, medicine and surgery, an MBA in healthcare management, a postgraduate diploma in public health, executive management and coaching, and digital health. I'm not a lawyer. And so therefore, I will have to consult in order for me to communicate the right and legal findings for this August House, and I stand on it. Secondly, suicide is not mentioned, but neither is any of schizophrenia then is not mentioned. Major depressive disorder is not mentioned. Personality disorders are not mentioned. Delusional disorders are not mentioned either. The reason for that, and we covered it previously during the discussion phase when we said the specifics are then covered in either rules and regulations or the actual regulations to come. None of the other conditions are mentioned, and so we cannot mention one and then leave out the other. Then with regards to the case of the traditional that must be once again included. So one of the key things that we must very carefully understand is because that bill that I've mentioned, we are at an advanced stage, has not yet come to the August House. There is currently no law that recognizes and regulates that particular field. And because of that, the inclusion thereof would do a big disservice legally because it is not yet recognized and legally mandated. And so that is the reason why we said it must wait for that bill that is at an advanced stage to come into the August House. Thank you very much.
Honorable Ampanda.
Thank you very much, Deputy Chair. Deputy Chair, we do have, for instance, so that we can understand what is happening with it, because the member rose on procedure. What do we do with regards to the gaps? Look at clause 28 of this bill. I wasn't here yesterday. Look at clause 28 so that I can just alert you, Minister, what's going to happen in your life now. Clause 28:1 say a person may not.
Amupanda, we are done there.
I'm not saying, I'm not going to the clause. I'm making a point on procedural point. Just allow me to finish. It says that 28, Reverend April was just saying exactly that same thing. So, clause 28:1 say a person may not, two things. A person may not offer consultation to or engage in mental health care of patients as such community-based mental health care facility. So this act that this clause that has been passed without any changes basically means without the minister. So the minister must give a license, says any person. So in other words, a traditional community that has a particular house where people visit for mental health. We know in the villages, mental health practitioners are there. So this bill 28:1 already says the person may not. So once the law says may not, it automatically says the penalties. So even if we are saying traditional leaders who have already legal basis in terms of the practice for culture, which is provided for by the Constitution, not that they don't have a legal basis, they are given that right by the Constitution. So 28.1 says they may not until they get the license from the minister. So if you know any traditional leader, ask them to come to the minister to get the license. That's effectively what it means here. We are not talking about regulating traditional leaders. So the members are correct. Because you are not saying regulate traditional, because I have seen that bill. I have had it for about 2 years. That Traditional Health Practitioners Act bill of 2016, 149 pages. So I know exactly what Honorable Shifeta is talking about. But with regard to mental health, if you don't sleep well at night and you go to that house, 28A, 28.1, by implication, because if you're not sleeping well at night, it's mental health. If you are hallucinating at night, it's mental health. So 28.1, because remember, we did not define mental health because of majoritarianism. People did not want to have a definition of mental health. Effectively, mental health is open for interpretation by everyone. So those houses become illegal in terms of 28, what you have approved here yesterday with that clause. The minister must give them licenses. So how is the minister, if an application comes from Mbwale to the minister, what is the minister going to be doing? Is he going to be asking whether you have a medicine certificate?
Time is up.
You see? So you have those problems here. So is there on 28?
Time is up.
Yeah, so you know him.
Honorable Kumbwa. No, it can't be a general debate. It can't be a general debate. I think after this bill, before we bring another bill, let's agree, honorable members, that we must go through a process where we educate each other on the processes of a bill, of how we make laws. We need it. We need it very much. Because general debate is for anything on earth that you could debate on. When we come to the second reading, which is the committee stage, we are specific on the clauses. Now I've concluded with clause 81, which is the last clause before the schedule. Now we have a new Pandora box that we are opening. No. Honorable Kumbwa, let me listen to you and conclude and move forward.
Honorable Deputy Chairperson of the Whole House Committee. Yeah, I understand it is not a general debate. It's correct, fully understood. But the problem is, why is the presiding officer allowing the situation to go like this? Mm-hmm. Are we not violating the rules on committee state? How do we go about it so that we conclude? Because we are debating towards a no solution, while we are aiming to have solution to this bill. So I implore the Deputy Chairperson of the Whole House Committee to take control of the House according to the rule.
Thank you very much, Honorable Kumbwa. And that takes us to the final and last clause. Schedule. I put the schedule. Any discussion? Any objection? Agreed to. I shall now... We are done. I shall now report progress. I shall now report progress and ask for leave to sit down. It's clear. Wat wil je nog doen? Er is no title. Er is nog eerst in die andere kant. Los. gone through Bill 8 2025 and the following clauses have been deferred for amendments. Clause 76 and clause 77. Then I ask for leave to sit down.
Leave granted. Yes, thank you. Huh? Yes, Honorable Hengari. What point are you raising on?
Privilege. I know that we are not in committee stage anymore, but Speaker, the rapporteur or the deputy chairperson forgot to mention clause 81.
So no, I'm told that she did. Honorable members, yes. Yes, honorable members, I suggest that the House rises for 10 minutes. Yeah, for a break of 10 minutes. Okay? Yes. of this law. Now, having dealt with that part, we will now continue with the order paper until 12:30, unless if we agree otherwise to, 12:30. So unless if we decided to rise earlier. Now, having said that, I would now the bill is now deferred to the next sitting, as I have indicated. We now proceed to the next item, and I would like to call the secretary to read the second order of the day.
Resumption of debate on second reading, Public Enterprises Governance Amendment Bill.
Yes, thank you. That is what I tried to explain, Honorable Ricardo, your query about questions. To say today we are having a special session. Yeah, this is not a normal sitting of the Assembly. The normal sitting of the Assembly is on Thursday. We meet from 2:30 to 5:45. And on those ordinary sittings of the Assembly, that rule then applies. That starts with the routine of business, and then when we are done with the routine of business, the questions will take precedence now over all the other items on the order paper. So today, because it was a special session, we didn't go through that, we just went to the order paper. So now we have started with the first item on the order paper. We now have to proceed with the next item on the order paper. Yes, Honorable Ampanda, can we please now just really agree to be cooperative? Can you take off that jacket that you have so that I can give you the floor? Because I cannot agree. I can't ask you to take off the shirt, the sweatshirt, because it's unreasonable. But to insist on having the jacket, I think is not considerate. And I'll have difficulties. I will have difficulties because I am practically not enforcing the rules. And so, Honorable Member, I have already indicated to you, our rules do not make a provision for the ruling of the presiding officer to be debated at the time that it's made. But you have a right to complain about that and then have the matter brought back to this House so that this ruling can be overturned. I have indicated that to you. So I cannot continue to have a debate with you on that issue because we will be violating the rule, the two of us. No, Honorable Member, I will not give you the floor, Honorable Member, if you are going to insist on having that, because that's not a formal wear. It's not a formal wear. No, I have made the ruling, Honorable. I have made the ruling, and I have explained it. I have explained it already, Honorable Members. No, I have explained it. No. I finished already that part. I will not go back to that. I have made a ruling on the dressing code. Okay, very good. It is not very hard, really. I'm done. Now, on what point are you raising
On the
now?
point of procedure. So, Speaker, one.
On what are you raising?
You will understand now as I speak.
No. The rules say when a member rises, the presiding officer would ask on what point.
The rule also say you must explain your ruling. I asked you to explain
No,
what
I have explained the ruling.
You didn't.
Okay, now you are out of order. Now you are out of order, Honorable Ampanda. I'll ask you to take your seat if that's what you want to insist on. So I have ruled on that one. You can raise on a point of procedure. Okay, Honorable Member, can we hear each other? No. Okay, can you take your seat for a moment, Honorable Member? No. I just take your seat so that I can explain. Just take your seat so that I can explain. The rules are saying when a member is requested by the presiding officer to take their seat, they take the seat. When the presiding officer speaks, he or she will not be interrupted. You don't have to agree with me. But when I ask you to resume the floor, then you can say what you want to say. But the two of us cannot speak at the same time. That's all that I'm saying. So, and the rules are saying when a member asks for the floor, the presiding officer would ask on what point they are rising, and the member would say what point they are rising. You have finally done that. That's all that I was asking for, nothing more. So you may now take the floor.
Yes, firstly, I just want to remind you, Speaker, that
on what point now?
Procedure. The rule says that you must explain the ruling. It's there in the rules. The rules are not open just for you when you feel like it. So if you are making, I simply just ask. I complied. I don't agree with you. I just want us to proceed. But I'm simply asking, can you point me to the rule? So that you are saying, if I'm unhappy, I must go and challenge it. How am I going to challenge it if you don't explain the ruling in terms of which rules I have violated? That's all I'm asking. 2, when we agreed to this thing, we can now see what this whole chief whip thing is about. When we agreed, the reason given to us is that no, some members are going to travel to Opuo. That's why we agreed to the sitting of today. We agreed to the sitting of today to say we are moving the session of 2 o'clock to the morning. We did not agree to a sitting, a special sitting, to do any other things. So it's very clear that one, when our members, I'm going to give an order, none of our members are going to attend to that chief whip thing. So, because every time there are no minutes, it's a point of, you said, it's a point of procedure because Speaker, you indicated, you are explaining what type of session are we having today. You are saying we are having a special session, but that's not the consensus. The consensus is that it's a public holiday, people are going to move and travel, that's why we agreed. So now we are called to those meetings, we agree. After we agree, there is a different interpretation. So we will be dealing with those matters here in the House. So it's not correct, that's what I'm rising to say. It's not correct to say that we are having today's session, there will be no answer to questions because it's a special sitting. That's not correct. The correct version, we were asked for indulgence and we agreed to it. That the session for the afternoon must come in the morning. That's what we agreed to. And we then understood that the question and answers is going to happen in the morning. I asked our chief whip, how do you know that ministers are not going to be busy? How do you know that ministers are going to be there in the morning to answer the question? Yeah, so we were assured, okay, no, it was agreed. We will no longer be participating in those chief whip things because there are no minutes. We don't even know. We were just told on WhatsApp and what the outcome of those meetings are not what has been communicated. Because when we advance that point, the argument has been made. Yes, chief whip, they can meet what, but the body is here. So as AR, since we are the target, we will just be meeting any issue here on the floor. We will not be meeting any issue on chief whips because there's no respect of chief whip forums. That's just what I wanted to say, that let's not interpret the consensus that was reached about what today's session should be about.
But I think you now just got out of order because instead of raising a point of procedure, you just challenged the rulings and then you issued threats and ultimatum. And now I don't know how to rule on that because I can't rule on a threat. I can't rule on an ultimate. No, honorable member, I listened to you when you were on the floor. You see, no, you okay. Yeah. So now, just to clarify the issue of honorable members, when we have different views, we can only, but honorable member, really, is that procedure, your conduct? You are out of order because I listened to you, now you sit and you speak over the presiding officer. That's out of order, and I have no other choice than to just rule it out of order and not make a ruling on that one. And I see that there are some requests, but before I do that, I just want to clarify the issue of the dressing code, which I have explained, and I want to emphasize again that in terms of the rules, the presiding officer can be requested to explain the ruling, and the presiding officer must explain the ruling, which I don't have a problem to do, and I have done already. Actually, I have done that, and we went on to discuss the committee stage, and now I'm being requested to go back to that one. But the members, but the staff member did not give me the dressing code. No, I have it. I don't say that I don't know it. It is in the rules, and you are out of order also to interject. But the rule on the dressing code says the members. No, you were taken through the induction. Yeah, and you cannot interrupt the presiding officer when they are speaking. So a sweatshirt. A sweatshirt, yeah, Rule 73.4 says for purposes of sub-rule 2E, for a male member, the dressing code is a formal executive suit or a pair of long trousers, a shirt with or without a necktie and jacket. 2, traditional attire. 3, a safari suit with long or short sleeves. And they did say etc. So it means that the beanie, the fluffy jacket or whatever terminologies we use are not there. I just want to remind the members, I am explaining, I am not debating. I am not going to entertain any request to discuss it. That is not a formal one, that's my ruling. You can appeal against it. You can appeal against it. Honorable Muton, you have the floor. You can appeal against that, Honorable Ampanda. You can appeal. No, you can appeal. No, Honorable. No, Honorable. You have the right. You have the right to appeal. You have the right to appeal. Honorable. No, you are not abused. You can appeal. Just follow the procedure. Honorable Muton, you have the floor. Yeah. Honorable member, you have the floor. You are out of order, Honorable. You are out of order, and you are out of order, Madam, speaking from your seat. Let's just, Honorable Muton, you have the floor. Honorable Muton, you have the floor. You Honorable, yeah, please just proceed. Proceed, Honorable member. Honorable. Yeah. No, Honorable member, Honorable member, please proceed. Honorable member, please proceed. Just proceed, Honorable member. Yeah, Honorable member. Yeah. Okay, let's proceed, Honorable member. Yeah.
Thank you, Honorable Speaker. Just on a point of clarity to understand, just to remind you, last week, Honorable Speaker stated that we should not follow the order of the day in terms of asking questions, and that will allow the ministers more time to answer questions as it is the last session. And as this is a Thursday, questions are prioritized over any other order of the day. And I know that we made a concession for the mental health bill to proceed, but now I just implore the Speaker to make a ruling in terms of the ministers being able to answer the questions so that we can make progress on that as well, as that was your indication last week Thursday. Thank you very much.
Yes, thank you, Honorable Muton. I get the point that you are making. And yeah, okay, so there is another member that wants to. Yes, Honorable Mwashindange.
Thank you very much, Honorable Speaker. I just want to take the floor so that you address it together, because it's more or less the same. Honorable Speaker, last week you informed this House. You implored on us so that we suspend the question, so that because you are addressing how thick the question book is. And you are on record saying the question book is too thick. Can't we use Thursday to suspend the other things so that the questions and answers take precedence? Now, having taken that as consensus, Honorable Speaker, I have not seen to this effect any motion that says this Thursday should be a special sitting. The only submission I've heard is from Honorable Cooper, and it only says that we consider sitting today in the morning, since the members would love to travel in the afternoon. And to our understanding, that does not make it a special sitting, because we were still going to sit today in the afternoon. But the consensus was, since the members, some of the members will be traveling and so forth, should we then consider moving the time? It's only the time, not the date. It's only the time to accommodate those that are traveling. And we agreed to that. You know, I thought, really, Honorable Speaker, I thought we should really find each other to stick to what we have agreed. Because we agreed as a House, I thought it would help us really to move in that direction going forward. Thank you so much.
Yes, honorable members, first I would like to appreciate the manner in which those interventions were made, although very strongly argued, but put within the spirit of the rules that we have adopted. And I want to say, as I have indicated in the beginning, the interpretation, you know, in the rulings that the presiding officer has made, and I refer to what was said also by Honorable Nekundi, the interpretation initially that I had was that if we are meeting, we go through routine of the day. Yeah, and I was reminded that in terms of the rules, if we meet outside of the hours of dealing with that issue, that's a special sitting that deals only with specific matters. And that is why on that day when it was raised, I just agreed with it. And that the same argument that I used this morning. And that understanding proceeded with the rest of the issues to say, if we have agreed to say we go straight to the order, then that's an agreement that we are also not going to consider the other aspects that are routine, how do I say, normal business of the day on a normal sitting of the House. And I thought that we can use today then to just proceed to go through the order paper. But if the House want to agree, you see, because in terms of the rule, the presiding officer makes a ruling, provided that the presiding officer can also decide to put the matter to the House for a decision. Yeah, so because for me, it's only about complying with the rules. So if the members would want to agree to say, after this bill, we must go to answering of questions, I want to put that matter to the House in terms of Rule 5. Yeah. So is it agreed, honorable members, that we go to the answering of the questions? Yes. Yes, yes. No. Yeah, honorable members. No, honorable members, can we please have orders? You see, rules are rules. We cannot comply with parts of the rules and not comply with the others. And in as much as you want me to be consistent in the application of the rules, I also want you to be consistent. Because you can't sit violating one section of the rule and you are saying, Speaker, the other one is violating another. So two wrongs don't make it right. But I have made an appeal yesterday to say the Chief Whip's responsibility include, Honorable Kandarodu, can you take your seat for a moment? Because the rules say when the presiding officer rises, the member will take their seat. The Chief Whips must please ensure that their members comply with the rules, because the reason why we have Chief Whips is for them to assist the presiding officer. Yeah, yes, he is a Chief Whip. And the Honorable Kandarodu, I am expecting that after, that I will never see you again violating the dressing code. Yeah, because I know Honorable Kandarodu, he understands that when he is out of line and he is called back to the line, he will come to the line. So Honorable Kandarodu, you are ordered. Yeah. Yes. Please, yeah. Honorable, but the way you raise issues is unprocedural. No. Then proceed, Honorable Kandarodu. Proceed.
Thank you, Speaker.
No, that's unacceptable. Yes. No.
My apology.
That's unacceptable. You are unacceptable. No. I cannot consider a matter that is unprocedurally raised. Yes, Honorable.
Okay. No. My my apology for the dressing code. Why behave? There is a presiding officer in the house.
Yeah, and him also, everybody must comply. Everybody must comply. Honorable members, the presiding officer cannot be reduced to telling elected leaders, national leaders, how to comply with the dressing code. That is something that I used to benefit from my teacher when I was in sub B. She'll tell me, no, you can't dress like that. But I'm not expecting to tell elected leaders, you can't dress like that. So honorable members, can we all just comply? Can we all just comply with the dressing code? Yeah. Yeah. Honorable, can you take off your jacket?
Yeah, no,
you must take off your jean jacket. And everybody must take off theirs. No, the jacket. Yeah. Yeah, okay, honorable members. No, honorable members. Please, we are wasting time, honorable members. Yeah. Yeah, at least. Yeah. No, honorable members. Okay, proceed, please.
Thank you so much.
Yeah. Proceed. No, we must be practical. We must be practical. I'm expecting that next time there will be no one wearing jeans and all kinds of footwears and headgears and so forth. Yeah, proceed.
Okay. Thank you.
The presiding officer interprets the rules and make rulings that must be complied with until appeal. Proceed, honorable member.
Thank you so much, Speaker. My apology for
anyway, this matter is referred to privileges committee.
Yes.
Yeah.
No, on the issue at hand, on the issue at hand, I think Thursday is very important day, not yet. But there must be kind of cooperation between Parliament and executive member, because Thursday is their day. Today is like a cabinet day to them. Tuesday and Thursdays is their day. So they must prioritize to attend Parliament on Thursday and answer to the questions. So I think we need to make some arrangements, special arrangements, behind closed door, so that we can find and harmonize the process on how to answer to the questions and minimize the thickness of the questions that we have. So
very good. Thank you.
Yeah.
Honorable members, now, because we are now eating into the time, that is not enough that is left for us to deal with the item. I have already indicated that in terms of the rules, the presiding officer can ask the House, to rather decide on the matter. And I was asking, are we agreed now that we go to the questions? I didn't hear objections. So please, are you objecting to that one, Honorable? Yes. Remember, we are eating into the time for the answering of questions.
Yes, Speaker, I fully understand that we are eating into the time. But yesterday I came here with a question that I wanted to pose on the floor. I was told the time is over. In fact, Honorable Speaker, there is a motion here for leave of absence that was supposed to be tabled, because on my behalf. It was not tabled because we were told that we have to deal with priority bills or whatever that story was. So really, Speaker, are we saying we're going back? And if we're going back, then we should go back to question time then.
Yeah.
And also allow us to also table our notices and all these other things that became, unfortunately, collateral damage.
Yes, thank you, Honorable Member. I think reasonability would dictate that where there is a motion that is requesting for leave of absence, that be considered. Because we don't want to generate unintended consequences when this leave is not granted. So, and then we agree that we just go to answering of questions. Can we agree on that one? Yeah? No, please. Just the motions that deal with leaves of absence. Yes, only that one. Yes. Are we agreed? Yeah, very good. Honorable Fries, is it a point of order? Okay, okay. Honorable Fries?
Thank you very much, Honorable Speaker. I move without notice in terms of Rule 124H, read with Rule 76, 1D and F of the Standing Rules, Orders and Internal Arrangements, that leave of absence be granted to Honorable Koviao Hengari during the period of 5 to 13 June 2026. I so move, Honorable Speaker.
Yeah, where are you going?
Parliamentary diplomacy.
Where is the question paper? Yes, Secretariat, can you help me to get the question papers? Where is the question paper? I'm waiting for a copy of the question paper. I thought it was here. Yes, I think the point was made. That was the point made. And yes, in terms of the rules, the ministers are supposed to be, as part of their accountability to Parliament, be available to answer questions. When they are not in the House, they are supposed to have leave of absence to be away from the House, as is the case with everyone. So that's not something to be discussed. So the chief whips, as I have indicated, and the leader of government business are to take up those matters. Otherwise, we will not be able to properly discharge our duties and responsibilities. Now, the first one is by Honorable Kalangula, question 125, to the Minister of Works, who is not here, unfortunately. Yeah. The next one is question 131 to the Minister of Education by Honorable Swartboy. Minister of Education, Deputy Minister, are you delegated to answer? Who puts the question on behalf of Honorable Swartboy? It's question 131. Is there anyone put? No? No one delegated, so the question is not put to Honorable Barotti. Then the next is 132 by Honorable Thomas. Is anyone delegated? Okay. So the next one is 133. 133 by Honorable Thomas again. Okay, not here. The next is 138 by Honorable Swartboy to the Minister of Justice. They are both not here. Yeah. Then the next is 139 by Honorable Swartboy to the Minister of Justice. They are both not here. The next is 140 by Honorable Ehub to the Minister of Urban and Rural Development. LPM is not here. The question is not put. The next is 141 by Honorable Ampanda to the Minister of Justice. The Minister is not here. The next is 143 by Honorable Ihemba to the Minister of Home Affairs. Honorable Ihemba is here. Minister, is there Deputy Minister? No? Okay. The next is 146 by Honorable Lucato to Honorable Minister of Urban. They are both not here. The next is 148 by Honorable Fries to the Minister of Finance. Does Honorable Fries put a question? 148.
Yes, Honorable Speaker, I put the question.
Honorable Minister of Finance, you have the floor.
Although the events have overtaken it.
Thank you. Thank you very much, Honorable Speaker, honorable members. Thank you very much, Honorable Prince, for your question. I might not go into the details because the matter is also in court, but there are some specific information that I would want to share, if that is fine. Regarding question 1, I tend to believe that you all have the questions. Question 1, the answer to question 1 is that the ministry has put in place transitional arrangements to ensure that employees are not unfairly penalized in terms of their interests and so forth. Existing personal loans will continue to be administered internally under the PDMS until everything else is addressed. Now, question 2, I wish to indicate that while payroll deductions provided repayment certainty, they also created, like it has been disputed, that they created some preferential access for institutions with deduction codes under the environment of competition, and these are things that we are looking at. Therefore, what we are then considering is that since there is a payment system that has been established, we are exploring the possibility of people to make use of that non-pay, it's called non-pay enhanced debt order, which will allow then repayments to the creditors to be effected through that mechanism. On question 3, honorable members, on question 3, the ministry is mindful of the unique challenges faced by the lower income and rural workers, and we are engaging with the financial institutions to ensure that employees are not left worse off because of this reform. And specifically here, I wish to indicate that what is really harming our civil servants, let me speak on behalf of the civil servants, and the public in general, who go for lending from, borrowing from the micro lenders, are the high interest rates. And this is what we are now currently addressing in the micro credit bill, so that at least we look into the issues of interest rates as now per the usury act, which is quite high and is really what is killing our people who borrow from the micro lenders. Question 4, how has the ministry again assessed the likely impact on interest rates? It's the same thing that I have just discussed or explained, to say under the current usury act, the interests are quite really high, because it's prime times 2. If prime is $10 times this 20, and that is very high. And those are issues that I have said that we are looking into them as and when we are finalizing the macro credit, the consumer credit bill. Number 5, how does the ministry plan to ensure that insurance companies can effectively transition premiums to bank debit orders and so forth? In that regard, as I have alluded to earlier, the ministry will be working closely with the concerned financial institutions to ensure that the transition does not negatively affect the employees. Right? And then I also just want to reiterate that the reform that we have implemented is that the PDMS administrator, the contract came to an end on the 30th of November 2025, and that now the ministry has taken over that administration. And then, perhaps it is now moving to the end, it is important to indicate that as of June 2025, we had like 893 micro lenders who were registered. And all these micro lenders are eyeing to offer their products to the employees, especially the civil servants. And this is what we would want to contain, because just imagine, all of them have been given a deduction code, yeah? Almost everyone will go to all these 900 or 893 microlenders, and remember, again, the issue of the interest rate. So we really want to make sure that the reform looks into all these aspects, so that then the reform really protects the civil servants as was the intent right from the beginning. With that, Honorable Speaker, Honorable Fries, this is what I could give, and I have really tried to give it almost all, but really the matter is also in court. I so submit. Thank you.
Very good. Good. The next question is 149 by Honorable Mongo to the Minister of Justice. The Minister is not here. The next is 152 by Honorable Klute to the Minister of International Relations. They are both not here. Honorable, does someone put a question on behalf? Where is the Minister? Okay, wait, who moves on behalf of Honorable Klute? Huh? Yeah. So, the next is 153 by Honorable Kandorodu to the Minister of Finance. Yeah, do you put the question? Yes, Minister of Finance, you have the floor.
Thank you so much, Honorable Speaker, Honorable members. The question by Honorable Kandorodu, and he always does this on purpose because he knows that the social grant management cuts across two ministries. That's the Minister of Gender, Equality and Child Welfare, and the Minister of Finance. But I have consulted so that we can address this question in a holistic manner. The question by Honorable Kandorodu, and they are really, really pertinent questions that he had raised. So, why does it take long for someone to be registered for a pension grant? I think that was the question. I looked into the process that the Minister of Gender normally takes. So it's the issue of attestation that really takes long. After the beneficiary has then applied, and then they go through the process of, it's a manual process. It is verified at the regional level, then it comes to the headquarters. It really takes long. We acknowledge that it takes long. And on average, it takes like 2 to 3 months. This is what the officials told me, and I have also looked into their documents. That's now the Ministry of Gender. So it takes like 2 to 3 months, and they really have said it's because it's a manual process, and first at the regional level or wherever they first do the registration or receive the application of the beneficiaries, and then that's validated at the headquarters. Then, of course, they do now the batching and all these other things. But when it comes now to the payment, once the validation is done, that one doesn't take long. It doesn't take long, because if a pensioner is registered hypothetically in April, right? If the payroll has not been processed before the application was loaded, right? Then it will go through the payment of May in this case. But if it was after the payroll has already been loaded, then that pensioner will only be paid with the payment cycle of June. And they have said that this is normally explained to the beneficiaries as we progress. Question 2, again, why don't the pensioners receive back pay for the waiting period after registration for the grant? This one we are going to consider. Yes. Because constitutionally, it's supposed to, you are entitled to get your money once you have reached the age of 60. But I think it's something that we are looking at moving forward. Then, what happens to the money for the 2 to 3 months? It's the same question. This is basically the same. Then, last one, does this mean that a pensioner must register for the grant 2 or 3 months before turning 60? I think this is just a way of saying, what will be the alternative? If I cannot get it after 60, can I then be allowed to apply before 60? No, the law says only after you have arrived at that age of 60 that you are entitled then to apply for your grant. So I believe, Honorable Kadrodu, thank you very much for your 4 questions, and these were my answers.
Yes, thank you very much. I think that's one of the important issues that I refer to when I say really questions sometimes only get us answers, but not the action that we require. And the minister has assisted us by indicating that she would look into that matter. Yeah, I think the Honorable Kandrodo won't have a follow-up question, so we can proceed to the question of Honorable Mbuti, 156 to the Minister of Gender. Is Honorable Mbuti here? Yes, the Minister of Gender, they are both not here. Unfortunately, Honorable Member, the Minister and the Deputy Minister. Oh, are they? No. Okay, the next one is 157 by Honorable Hengombe to the Minister of Industries. Honorable Hengombe, do you put the question?
Honorable Speaker, I put the question.
Yes, Honorable Minister, Mines.
Thank you, Honorable Speaker, and thank you very much, Honorable Hengombe, for the question. Honorable Speaker, this question is overtaken by events. It's my hope that perhaps this information was either given already or otherwise, whatever the questions now contain here are no longer relevant, and because none of these events have taken place. Maybe they were based on the allegations. But however, the advice I got is that this information were overtaken by events and information were given. That's what I'm getting.
Well, how were they overtaken by events? Honorable Member, maybe you can assist.
Honorable Speaker, I got information that the questions relate to an arrangement, an alleged arrangement to be done supposedly by NAMCO. Which number 4?
Members, just answer.
And this arrangement never took place.
Yeah, Honorable Minister, I think it would be good to just answer the question. So if the member's question implies something, just answer and say, in the question you are saying this is not correct, so that there is clarity, because otherwise, even the members of the public who read these questions, they won't know what clarification the government is providing, unless if the minister wants time to look at the questions and provide an answer. But I think it's an important issue. It will not help us to leave it unanswered.
Honorable Speaker, the information at hand regarding this question, number 1, it relates to an alleged arrangement for the bailout of NAMCO. What is right at the moment is that NAMCO was not bailed out by any foreign institution, and that arrangement never took place. So what happened actually is that the government itself took over whatever was supposed to bail out NAMCO, and it was actually the government that attended to the financial needs of NAMCO, and not any foreign institution.
Okay, thank you. So that there is the answer, Honorable Hangover. Very good. Now, no? Huh? Yeah. So, honorable members, yeah. Okay, so, honorable members, I hear very important queries being made, but we must always comply with the rules, as I have said. The rules provide the right to the mover of the question to ask a supplementary question, not to just any one of us. But what I picked up, which maybe is important to note, is to say, honorable ministers, members are saying on important issues that they query, they need written information. Yeah, so for the future, please, because now we are relying on the Hansard. Yeah. Yeah. Yeah, honorable member, honorable Hengobe, I can't make the minister to write an answer now if he doesn't have one. So unless, you see, so unless if we agree to defer the answer so that the minister can provide a written answer. And I did offer that, but I can't make him to write now. Yes, Minister.
Thank you very much, Honorable Speaker. I can provide a relief probably to the question, because I'm willing to provide further information. Like I say, it was my understanding, Honorable Speaker, that the information was provided. I'm getting it now that the information wasn't provided. That's why I said it's probably overtaken by events, the question itself. But I can make either a ministerial statement on this one and I clarify everything. Maybe during the next session.
Yeah, so since the minister, thank you. Since the minister has already answered, we can't defer the question anymore, but the minister can provide either a ministerial statement, I think, as he has offered. I think that would assist. Agreed? Okay. Then, yeah. Honorable member, on what point now? I'm challenged because in terms of the rules, I can't give an opportunity to any person other than the mover to query on a question that was posed. So on what point is the honorable? Okay.
The rule says that we must go and write. The questions must be written. So the answers must come back in the same manner. We take efforts, we go out and do research so that we can ask these questions, but the minister comes and do not just do justice, just answer question 5 and then that's it. It's not fair, Honorable Speaker. With due respect, as much as we take time to bring questions, please do the same. Thank you, Honorable Speaker.
Yes. Yeah. Okay, honorable members, please let's go easy on the clapping because the hands are, yeah, no. Honorable, the rules are saying the presiding officer should use this to draw attention, but there is nothing, no, honorable members, there is nothing that gives the right to the members to bang on the table, you can clap. So now we will not discuss that part. But I just would like to agree, because the point that was made is the point that I make every day. The rules are saying questions must be notified in writing, yeah? And only on the discretion of the presiding officer can unwritten questions be posed. So I think it does make sense that the answers must also be in writing. But I was faced with that dilemma. That's why I first asked the House, in terms of Rule 5, or is it Rule 6, that said the presiding officer can make a ruling or can ask the House to discuss the matter. So I asked, should the minister defer so that the minister can come with a written answer? But we agreed that the minister must answer orally. So please try to understand my difficulty also to say, if I say the minister must answer orally, he cannot answer orally, and then after that I say we defer again. But maybe, I am not aware of that one, Honorable Ampanda, and also you cannot please do that from the sitting position. No, Honorable, you are out of order. So I can see, no, you can't do that from a sitting position. You are out of order. Yeah. So no, I got that agreement, but in that case, if the House is of the view, you know, because it's the first time that we are dealing with this issue, not because Honorable Ampanda said it unprocedurally, especially considering really the way the member brought the matter. We defer the answer. Honorable ministers, please always bring your questions in writing. Honorable members, please always pose your questions in writing. Because at one point, the presiding officer is going to rule out oral agent questions. It's not being oral. Yes, that's not a choice that you have. Yes, that's not a choice that you have. Now we proceed to 158. 158. 158. 158. Honorable Nashinge, you have. Honorable Nashinge, do you pose the question? Yeah. Oh, the Prime Minister is not here. The next question is by Honorable Klute, 159. Is the question put to the Minister? The Minister is also not here. The next is 163. Deputy, are you delegated? But the member is not here to put the question. And the question was not put. Now, the next one is 163 by Honorable Fries to the Minister of Agriculture. Both the Minister and Deputy are not here. The next one is 164 by Honorable Lizazi to the Minister of Justice. The Minister is not here. The next one is 165 by Honorable Klute to Minister of International Relations. They are both not here. The next question is 166 by Honorable Amkoto to the Minister of, do you put the question? Yeah, the Minister and the Deputy are unfortunately not here. Yeah, Honorable Lizazi. Honorable Likando. Thank you. You are very useful in your comments today. Thank you. That is noted.
I just want to put it to the Speaker, because we are always blamed that we are asking a lot of questions. That's why we have this thick book. But it is evident today why we have this thick book. Because ministers, some of them, they are ever absent from their duties in Parliament. That's why we have this thick book like this, Honorable Speaker. And it is on record here. One of the ministers was complaining last week that we are asking a lot of questions, but where is the minister now to answer? No, and it is their job to answer this question.
Okay,
so thank you very much. I just want to put it on record.
Yeah, Honorable, thank you.
And the others were here, they left.
Okay, please take your seat. Honorable Ricardo, that's a point that was made already, and I agreed with it. And I have also made this several times. I agree that when we have work to do in the House, we must be in the House, all of us. Yes. The next question is 167 by Honorable Ipumbu to the Minister of Works and Transport, and they are both not here. Next is 168, Honorable Ipumbu to the Minister of Works, they are both not here. The Deputy is not there. The 169 is by Honorable Ampanda to the Minister of Finance. Honorable Ampanda, do you put the question? Yeah, Minister of Finance.
Thank you so much, Honorable Speaker, honorable members. Thank you, Prof, for the question. The only difficulty that I have with the introduction of Prof's questions is that it started with mentioning the names, and I'm not sure whether the rules allow us to mention names. But because the question needed, or it was seeking for clarification on whether, and I think I should provide the context, that the cited minister joined the Ministry of Finance in June 2003. I think it's May 2003. And by that time, we went to some records. By that time, the principle of going out on tender and so forth for the two systems, that is the PDMS and the IFMS, it was before the time of that minister. However, the awards happened around the same time. I just wanted to give the context without mentioning the name of anyone. But I want to go to the specific questions because Prof had really asked pertinent questions in as far as the IFMS is concerned. PDM is the other one that had the middleman. The IFMS is concerned. And I want to talk to question 1 of IFMS. That is to say, historically, the administrator has been with this tender for so long, which is true. And we even ourselves, Prof, we are concerned about this administrator. It's supposed not to be like this. Last year, we kept on asking, why extension? But you know technicalities now, I understand when people complain about technicalities. It goes to the Central Procurement Board, then it comes back to the Ministry of Finance, technicalities, amend there. So, to such an extent that even as I'm talking, on the 26th of April, again, it went back to Central Procurement Board for it now to be re-advertised. Back to Ministry of Finance, technical questions. There is where I need to say, it is true, we are all frustrated, but ministers, you are not allowed to touch anything related to procurement. We can only ask them to speed up the process so that we are not really being seen as favoring only one administrator for this system. So that is just the history where we are. Prof, to say the process is not yet out. We are not yet out on tender. In other words, Central Procurement Board has not yet gone out on tender because the documents were referred back to the Ministry of Finance on the 28th April 2026. That was on question 1. Question 2, again, the question is saying, why can't what had happened with PDMS, why can't it happen with IFMS? In other words, why can't we do away with the administrator and for the Ministry of Finance to take over this system? This one, Prof, is a complicated one, a little bit, because the functionalities are Oracle-based. And I will seek your indulgence on this one. It's Oracle-based. And the products of Oracle, as I understand it, only the authorized dealers can make use of that. Maybe it's a platform, I don't even know how to call it. And for now, in Namibia, apparently, I still need to verify, apparently there are only 3 dealers, authorized dealers, to use Oracle products. So it then means, us as the ministry, if you would want to make use of the Oracle products and us to take over that system ourselves, it might be a challenge because we are not authorized dealer for Oracle products. But that does not mean that we cannot go out on tender so that then the other 3 or 4 authorized dealers can compete and so forth. And the IFMS is equally due for advertisement. Right, then question 3, is it not clear as daylight that in this financial process, the middleman does not initiate or complete anything? No, for now, what they do, they complete the work. When you give them an assignment, if there is a module that has got issues and they need to perfect it or to correct it, that they do. They complete the tasks that are given. But I believe the sentiment of the House is to say, why can't we give opportunity to others to compete? And that one we have heard about it, and we are going of course, we are going out on tender. Question 4, and it's the last one. Prof, again, it's almost the same thing, just to say, why can't we then make use of Bank of Namibia to be the one, for example, helping us to administer the system? For now, the Payment System Management Act that's managed by administered by Bank of Namibia, it does not really allow for the technicalities. It's more on the payment side. It's not on the functionalities. Like I have said, we have like 7 or 8 modules for the IFMS, for the Integrated Financial Management System. So the technicalities, the functionalities should be done by someone else. Whereas the payment, like it happens now, the payment is done by the Bank of Namibia through the payment system. I believe this is fine, and like I have said, we are amenable to suggestions. We also learn from the questions. That's why we don't feel offended at all. We provide responses where we can. Where we cannot, we can also say we will come back. With that, I thank you. I so submit.
Yes, thank you. Is Honorable Mpanda asking for the floor?
So thank you, Minister. I just have a small follow-up. You provide more clarity now. The follow-up, whether it's something that you could consider given the answers that you have given. Through our research, we also discovered that when the minister responsible for health took that revolutionary path of going directly to manufacturers, that process went to procure directly, and those manufacturers had actually have signed agreements with middlemen. So we just discovered somewhere through the process that the middlemen must authorize. It's worse actually, and the middlemen made more money from that direct procurement because they must sign, and in that agreement there's procurement, which is also the same that we are all talking about Oracle-based authorized dealership. It can be a manipulation or it can be real. There's that possibility. But also, it's the same thing that you saw with the locomotives. And they were saying there's only one, that General Motors or that American one for locomotives. Don't you think, as a follow-up, Minister, what our experience with procurement at health, our experience with this Oracle explanation that we're now hearing, don't you think you should actually commission the Central Procurement Board to have a research division? So that basically means that that Oracle, immediately when you are told that this Oracle issue, automatically they go and do research on the possibilities. Because now, even if you go and advertise, we are still going to do it blindly. We are still going to be told, no, there is no responsive bidding because of this Oracle activity. So you must already be in a position through the research arm of the Central Procurement Board. So I understand the module, and I accept, for instance, when you say it seems that the payment system is only at the end. It will not be able to accommodate the first modules of these payments. So don't you think really that might be the solution, to actually have a research arm? Any problem that we find, we throw it there. Then at least we have, otherwise Central Procurement will not be able to solve these problems. I just want to see your view on that one as a follow-up.
Yes, Minister.
Thank you very much, Honorable Speaker. Thank you very much, Prof, for that suggestion. It's a good one, because the Procurement Act also allows for research to be carried out. I will just discuss with the Central Procurement Board and the Procurement Policy Unit to check as to where is it suitable. Should it be with the Procurement Policy Unit, or should it be with the Central Procurement Board? But the principle is appreciated. And like I have said, it is really also in the spirit of what the law also envisages, that there should be research carried out, also to complement the actions that will be taken either by the board or by the Procurement Policy Unit. Thank you so much for taking it.
Yes, thank you. The next question is by Honorable Ampanda to the Minister of Works. Is not here. And maybe what I have to say is I think the Minister of Finance has alluded to the challenge with these questions. In terms of the rules, the questions may only contain people's names if that is a requirement to make the question intelligible. And the questions must also be of shorter length. So this time we have agreed to just let this question be put and answered, and put that to experience, leave that to experience, so that when we come back we make our questions shorter and try not to violate that rule. Now the Minister of Works is not here, there is no deputy. The next one is 172 by the Honorable Thomas, he's not here. To the Minister of Education, who is not here? Okay, Honorable Thomas is not here. Has he delegated someone? Okay, do you put the question? Okay, Deputy Minister, are you delegated? Okay, please.
Thank you very much for the question. So perhaps to start by giving a very brief background, the Namibia College of Open Learning facilitates face-to-face registration for learners at designated centers across the 14 regions. During the registration process, learners physically present themselves and select the subjects that they wish to improve, subject to availability at the centers. Upon registration, learners are issued with 1 study materials and 2 proof of payment receipts indicating the amount paid, as well as the subjects registered for. These processes serve as immediate confirmation and verification tools at the point of registration. Where subjects are not available or materials are depleted, learners are referred to the nearest alternative centers. Thereafter, all learning information is processed in the Student Information System for institutional administration and record keeping. Importantly, learners also register for examinations which are coordinated by the Directorate of National Exams and Assessments at our ministry, where they are required to present proof of having registered for tuition with NAMCO. It's important to note that the NAMCO learners are shared clients between NAMCO, and NAMCO is responsible for registering learners and providing tuition, and the DNEA is responsible for examination, registration, and conduct of examinations. Now, to respond to Honorable Thomas's very specific question, indeed it appears to have been an administrative error during the examination registration process that went undetected. That we have it on our record that this is a case of one learner who registered with NAMCO at Oshela SS in the Okongo circuit for English second language. However, her examination registration with the Directorate of National Examinations and Assessments reflected Afrikaans second language. The school principal confirmed the case and indicated that the matter had been referred to the Regional Examination Officer in Ohangwena. The feedback received was that the amendments to the examination entries could not be made for part-time learners if learners had not verified the examination entries. This learner seems to not have verified her examination registration. And to question 2 and 3, after registration, learners are given a chance to verify and correct the subjects before examination. This is because the Directorate of DNEA provides a 4-week verification period for learners to check the correctness of the examination entries. This period is widely communicated through the various channels. To question number 5, should DNEA permit the learners to sit for the examination? NAMCO's position is that no loss of service delivery has occurred, since these learners would have received full tuition and academic support throughout the year, with the matter only arising upon receipt of the examination admission permit. Honorable Thomas, in absentia, we want to conclude by indicating that the Ministry, NAMCO and DNEA remains committed to ensuring effective service delivery to learners and will continue working closely to develop the solutions that prevent similar occurrences in the future. We trust that this clarification addresses the concern raised and provides guidance for the way forward. I so submit.
Very good, thank you. Now, the next question is 173 by Honorable Lucato. Yeah, Honorable Lucato is here to the Minister of Industries, but I will have to advise Honorable Lucato that please, the question was not properly framed. So this, actually, I read it, it's not a question, it's just a statement and a request. So please, honorable members, not only honorable Rukato, but honorable members, let us look at the formulation of our questions so that they are questions. Yeah. Like even the last sentence, you could just have framed it as a question to make it a question. But yeah. I don't even know what to say. Do you put the question or?
Yeah. Thank you very much, Honorable Speaker. Before I put question, allow me to say, to respond to you.
No, Honorable, my brother senior. Let's not do that.
Honorable
Honorable senior brother, just take that advice and let's see whether the minister can do something with it. Because truly speaking, there is no question mark even anywhere when you look at that whole thing. There is no question mark. You only ended by saying, we kindly urge your office to consider a site assessment for the feasibility of extending the power line to their village and surrounding area. That's not the question.
I put question to the, I posed question to the minister.
Yeah, we could have said, can the ministry consider to, then that becomes a question. Yeah, so Honorable, maybe just to give that to experience, because, then next time you do better. Honorable Minister, if you were to consider that a question, what would be your answer? That's now hypothetical. I'm now violating the rules, but only flexibility to help the members to appreciate the rules. Yeah?
Thank you very much, Honorable Speaker and Honorable brother. I happen to understand the submission by the honorable member, and I will take it into that context of the understanding that I derived from the submission by the member. Honorable Speaker, I would like to thank the honorable member for raising the matter of Kavimba village in the Sibinda constituency of access to electricity that remains a clear priority for government, particularly in rural regions such as Zambezi, where the developmental impact is immediate and transformative, and indeed all the 14 regions of the Republic of Namibia. Honorable Speaker, it is correct that the ministry completed the electrification of Old Masokotwani Primary School. The same project also extended electricity infrastructure to Kahunikwa, Nsundwa, Ikaba, and Malala Nkanga primary schools, while simultaneously connecting 3 churches, a borehole, and a clinic in Ikaba to the national grid. These projects were implemented on behalf of the ministry by our utility Nampower. The approach of electrifying public institutions first, particularly schools and clinics in previously unelectrified areas, is deliberate and strategic. By prioritizing these facilities, the government brings infrastructure closer to the surrounding communities while ensuring that institutions serving the broader public are addressed first. In the Zambezi region, I am pleased to report that all schools submitted to the ministry by the regional council and the Ministry of Education for consideration have either been electrified or are in the process of being electrified. Honorable Speaker, with public institutions largely addressed, the focus is now progressively shifting towards households electrification. However, expansion of the electricity network must follow a structured and coordinated process. Village and locality priorities are usually identified at the regional level as a structure through consultation with regional councils and constituency leadership. Thereafter, technical assessments are conducted by NORAD and Nampower to determine the most appropriate network development path, taking into account load demand, system stability, distance from existing infrastructure, and long-term sustainability. Once feasibility is confirmed, implementation is aligned with available budget allocations. This structured methodology ensures fairness across constituencies and preserves the reliability and integrity of the national grid. Honorable Speaker, with specific regard to Kavimba village, I note with respect the Honorable Speaker's observation that the newly installed line serving Old Masokotwani Primary School do pass within the proximity of 900 meters at that village. Given the relative proximity of existing infrastructure, Honorable Speaker, the Ministry have requested NAMPower to undertake a technical assessment to determine the feasibility as well as the estimated cost and the network implications of extending supply to Kavimba and surrounding households, my brother. As NAMPower and NORAD remain active within the Zambezi region, this assessment can be incorporated into our ongoing regional planning activities. The findings will guide the appropriate budgeting and implementation process. Honorable Speaker, government remains committed to accelerating rural electrification in a coordinated, fair, and sustainable manner. Infrastructure is being extended progressively so that communities such as that of Kavimba village are reached through proper planning and responsible network expansion. We appreciate the submission by my senior brother, the honorable member, and we assure this House that electrification in Zambezi region and all other regions remain an active and ongoing priority of the Ministry of Industries, Mines and Energy. I thank you, Honorable Speaker.
Much. Honorable members, is the Honorable Lukato having a follow-up question? Or a question?
Yeah, Honorable Speaker, my relative sister, let me thank my relative brother for the good response. I need only a copy because I have to go back to the masses for the feedback. Thank you so much.
Very good. Now, on the basis of the rule on automatic adjournment, the House would now rise until the 2nd of June 2026 at 14 hours 30.